with Mr. Sedgwick. Anybody doing it right?
I think that I'm seeing a silver lining on the cloud. Some of the AI platforms are beginning to listen and to adapt their systems to respect rights of authors, or at least they're saying that this is in progress. Okay. There's really two gateways here. There's the gateway to allow works into the databases that are used for ingestion of images into these systems. And then there's also a gateway in terms of the prompts that are entered and also uploaded.
All this shit is, all this is very, very, like, I urge a lot of y'all to really do your research.
Putting of images as image prompts, copies of our works uploaded by others without our permission as image prompts. Those two gateways are of concern.
And Mr. Navarro and Mr. Irwin, could you offer me your thoughts? Anybody doing this right?
I'm not aware of who's doing it right, but I don't believe that everyone is doing it wrong. I think it's so brand new as that it's the Wild West out there. I think of the earliest days of sampling.
You know what gets me? How they keep saying it's so brand new when they've been talking about cloning and robots since way before the 70s. Since way before, like, all this has been here. They just, bringing it out little by little and making a lot of people think that this is something new, something they just came up with, something they just invented. Come on, man, think back, Egyptian time, when they did them hybrids with the humans, the animals, much more, how they, listen, man, it's really, I know y'all watch them documentaries and much more. I would love to hear what y'all think, once again.
When people sampled stuff for records routinely and didn't give credit, compensation, nothing. Now it's routine. Can't Touch This by MC Hammer credits Rick James for Super Freak, and his estate gets compensated. So we're in the process of trying to get it right.
Okay. Mr. Irwin, briefly, if you don't mind, I have one more question to ask.
Yeah, I have no knowledge of anyone doing it right. I think there's starting to be some overtures as to an inquiry as to let's get together and talk about it. But at the moment, no, not to my knowledge, no.
Dr. Callison-Birch, in the time I have remaining, I was particularly taken in your testimony by something you said about the impact on labor, on workers. You used the expression, you suggested, will paralegals go the way of the lamplighter? What are the implications for the labor market?
I think this is the large issue that everyone needs to deal with, and where.
That is a great question. Great question. What do y'all think?
Congress can have the most effect. I feel that at the moment we may be on a precipice of mass unemployment. I think the probability is very small, but it's such a dire outcome that you really need to consider some sort of legislation, like in case of emergency, start a new WPA. I think that dealing with this as a copyright issue almost entirely misses the point that these systems are coming, and we've in America experienced unemployment as a result of automation before. It's largely affected blue collar work, but now has the potential to also affect white collar work as well.
Fascinating. And Mr. Chairman, again, I thank you and I yield back.
Thank the gentleman.
Basically, like I've been saying, it would affect a lot of jobs. We're not talking about celebrity jobs. We're not talking about entertainers, artists, musicians, and lyricists and stuff like that. No, we're talking about us, the 9 to 5.
Lady, we now go to the very patient gentlelady, Miss Lee of Florida.
Thank you, Mr. Chairman, and thank you to all of our witnesses who are here today. We so appreciate your time and your testimony, helping inform us about how we might embrace the emerging technology of artificial intelligence, but also recognize the immeasurable value of our artists and the need to protect and balance intellectual property and copyright protections. I'd like to return, Mr. Damley, to your testimony, and specifically during the questions by Congressman Moran and Frye, you talked a bit about your perception that existing copyright law was adequate to take on this new emerging landscape and continue to resolve that balancing between the property rights of artists and in our new technology that we see. One thing that concerns me is that when Congress fails to be sufficiently clear we leave to judges the task of figuring it out. And of course, we want judges applying the law, not creating it. We don't want to put judges in the role of being policymakers. So I would like for you to elaborate.
Yo, I'm gonna put this back for everybody. Like, yo, I've been talking about the judges, haven't I? I don't want to go back too far.
Thank you to all of our witnesses who are here today. We so appreciate your time and your testimony, helping inform us about how we might embrace the emerging technology of artificial intelligence, but also recognize the immeasurable value of our artists and the need to protect and balance intellectual property and copyright protections. I'd like to return, Mr. Damley, to your testimony, and specifically during the questions by Congressman Moran and Fry, you talked a bit about your perception that existing copyright law was adequate to take on this new emerging landscape and continue to resolve that balancing between the property rights of artists and in our new technology that we see. One thing that concerns me is that when Congress fails to be sufficiently clear, we leave to judges the task of figuring it out. And of course, we want judges applying the law, not creating it. We don't want to put judges in the role of being policymakers. So I would like for you to elaborate a little bit more on your conclusion that our existing statutory framework is sufficient to take on this new challenge.
Great question.
Thank you, Congresswoman. It's an excellent question. I think if you just look at history here, fair use has existed in the copyright law for about almost 200 years. And over that time, it's dealt with lots of massive shifts in technology. 1984, the Supreme Court applied fair use to the then new technology of VCRs and said, applying, again, a 180-year-old law that did not have any understanding of that kind of recording technology, and made a really fact-bound, cautious, careful decision about whether home recording was fair use or not. Fast forward through the era, recently the Supreme Court handled a case involving software APIs. Again, something no one could have ever dreamed of as being a copyright issue 180 years ago. Yet the court, again, looking at the very specific facts of that case, determined that the reuse of software APIs was fair use. And there have been other cases going the other way, looking at new technologies like Napster and saying that is not fair use, that's an exploitive use of the technology. And so my perspective comes from looking at that long history and how copyright law has been able to manage shifts, even major shifts in technology.
And Professor Birch, what's your take on that same question and the conundrum of not over-regulating, but at the same time, not leaving it to courts to try to create policy?
I think that it's worth considering all these issues and deciding whether or not copyright needs to be extended. I think that there's many things that my fellow panelists are talking about that are 100% valid and need to be incorporated into the ethical guidelines that AI system developers create, including right of publicity and copyrighted characters and things like that. And those are not currently covered sufficiently by copyright law. They may be covered by other laws sufficiently, but I think that's where the target should be. Like, what is the output of these systems and what is correct use and incorrect use of the output of these systems?
And Mr. Navarro, one of the advantages about getting to ask questions near the end is that I can bring to you this one. Is there anything that you wanted to share with the committee today that you have not to this point in the hearing been asked?
Great.
That's a good question. Yeah. First of all, when we look at the ingestion of trillions of pieces of data, that's one way of looking at it. But when we look at the impersonation of voices, that's really one piece of data. And that's very specific. And it's easy to get lost in the shift between the macro and the micro as we figure out where to go on this. I think we need to take a look at both. I think the other is that I appreciate the technology. I appreciate the technical use of terms, but my music isn't data.
And Mr. Irwin, the same question to you. Anything you wish to share with us today that you haven't already testified to?
I'm going to follow on what Dan said. I'm a little distressed that we're calling this training, to be honest. Because in my mind, we train athletes or animals. We don't train machines.
Boom. Yo, didn't I say that on part 3? I said that. And when I started this live, I said that you train an animal, you train a person for work. You train an animal when you tell them, you're training them to sit down, to bite, to, lay down, go to sleep. Like, you're training this animal. You're training a human when you're teaching them, how to work, an athlete, But a robot, somebody with no subconscious, somebody with no conscience, somebody with no feelings, no emotions, somebody that is programmed, everything that is in it is inputted. It cannot think for itself.
We equip machines with data, as the technology people like to call it, but as we like to call it, music. It's very Orwellian how the tech industry manages to change terminology on us. It's not data and content to us, it's music, it's photographs. It's not file sharing, it's stealing. It's very simple. They're the sort of things I wanted to get into the record that I didn't get to say.
Thank you. Mr. Chairman, I yield back.
A brilliant move for such a new member. With that, we go to the gentleman from Maryland for 5 minutes, Mr. Ivey.
Thank you, Mr. Chairman and Mr. Ranking Member. Ms. Lee, you stole my question there. I did want to go back to the deep fake issue. And Mr. Sedlick, I think you talked a little bit about technology that exists that allows, that gives the ability to separate out what is real and what is fake. And you said C2 something, and I wanted to get more details on that.
Great question.
Sure. So a consortium came together, managed, I think, by Adobe or founded by Adobe, and with various industry players. They explored methods of creating a technology that would allow you to use software to determine whether or not an image has been altered, and what the provenance of that image is. And that information is stored in the image, so that when you're using software to view an image, you can tell whether or not that image has been altered. For example, swapping out a head, changing something, removing something, adding something, any sort of revision to the image, to provide that information to the public and to people who might rely on those images. And that is C2PA.
Okay, here's where I'm going with this. So if I guess what you're saying is that, say, a movie or some visual depiction that has the code embedded in it, so that distinction could be made, then you have the software to identify it. I guess the question I would have is, what if it's not software generated, or if it's just a visual? Here's sort of the big question. So for example, body cameras worn by police, and I know this isn't a creative content question, but body cameras have become super relevant in court with respect to police cases. And in many instances, videos. Former President Trump's video in his most recent trial was pretty significant as well. I was sort of curious as if it's AI generated entirely. So you would take the subcomponents of the training piece or whatever, and I apologize. I went to law school instead of any kind of hard science classes, so I'm struggling with the technology terms. But would you be able to tell if an image or a video is generated entirely by an AI approach as opposed to some of it being real or some of it not? Is there a way that you could tell if it's authentic or not?
Why don't you just say that?
The AI platforms are doing some work on this and coming forward with technology to be able to allow the public to discern what is AI and what is not. With respect to other types of creations or recordings, like you mentioned, the police the police cameras and such, those embed time code and other information in the recording so that you can tell whether or not there's been anything removed. But in terms of finding something or determining whether an image is AI generated or not, that's right now at the experimental phase with scientists looking at it, image scientists, and I think we're going to see something in the very near future.
Okay, Mr. Navarro, did you have something on that as well, or?
From a musical standpoint, we sometimes use our taste. I did a touring test at South by Southwest in March where pieces were being played, and I was able to guess about 3/4 of them, but not all of them. Happened to be with very simple forms of music that were style-based. Sometimes the vocals were gibberish. Other times it just were moves made musically that no great musician or great producer would allow. But it gets more difficult. This particular piece that we just heard from the gentleman from Texas, that would have been really, really difficult to tell. And so from that standpoint, I think that's what one of the great dangers is in not knowing the difference.
And Professor Callison Birch, I wanted to sort of touch base with you on this kind of issue as well. I know we've been talking about copyright law, but from the standpoint of protecting the community, the world, whatever, from these sort of fabrications, which I don't know if they're illegal at this point or not, but you know, are there steps we need to take to address this?
Absolutely. My PhD students have done the largest ever study on human skill.
How they don't know if they're illegal or not? Like, aren't you working for the government? Shouldn't you know if this is illegal or not? I'm a little confused there.
Human detectability of machine-generated text, and we've found that over time, it's getting harder and harder to detect, but that people can be trained to detect. So I think similarly to how Dan is saying that the latest clip of the fake Drake song is increasingly passable as human, whereas 5 years ago it wouldn't have been. Like, that's a trend that we're on. And I think any sort of basic media literacy that we teach to our children should include this as an element.
Okay, and with respect to visuals, because just from the court standpoint on some of these images, sometimes people's, you know, whether you go to jail or not is determined by a visual or a video clip that a jury might see. I mean, are there ways to make sure that whatever is presented or a judge making a determination about what could be viewed is actually authentic?
There's expert testimony through examination of the images. I think you could likely still detect artifacts of a machine-generated image if it's done carelessly. I think it's going to get harder. So it's certainly something to keep under consideration as time progresses.
All right. Well, I want to thank all of you all for coming in today, and I apologize for a question that's a little off the topic, but I think important for us. And Mr. Chairman, I really wanted to thank you and the ranking member. I agree with some of the previous comments about this being a refreshing change from some of the types of hearings we've had, you know, previously. And I thank you for this.
Well, I thank the gentleman. I will welcome you to the subcommittee, which has historically been extremely bipartisan. So we're going to keep that tradition going when it comes to, we can't pass intellectual property reform except on a completely bipartisan basis. And now, last and probably least, you get me.
Nah, who we getting?
I'm going to start with this. Thank you, Mr. Ranking Member. This is an actual portrait. You'll recognize some of the characters. They're pretty much mostly all dead. Some of them, in fact, all of them were produced by an artist who took a number of photographs, including Lincoln photographs, in order to produce this product. I am confident that Andy Thomas did not pay for most of the photographs. Do you see a problem in, and I'll start with Mr. Navarro, in that being fair use, the collection of photographs, since for the most part, these gentlemen were not available to sit or stand for this portrait?
I think were it me, I probably would have made an attempt to compensate the photographers. I don't know enough about the derivative work clauses in the Copyright Act that can allow something like that. I happen to think that's a wonderful painting. And I'm a Democrat. I still think it's a wonderful.
I wanted to bring both because I have another one with all the Democrats. They both
Well,
hang in my office. You're welcome to come
And
afterwards.
as such, I mean, my personal opinion is that creativity's been enhanced and communication has been enhanced. However, were it me,
I have just one question for y'all. What? Not the chat, not the people that catch the replay. The people in the council meeting, the committee meeting. My bad, not the council meeting, the committee meeting. What does being a Democrat or Republican have to do with this? Real shit.
I would have made an attempt to contact the photographers.
And I believe that, he would have bought those pictures if they were commercially available, whether they were under copyright or not. And I point that out because it's one of the challenges that I face in trying to steer this committee now and in the future is I try to look back, as I did there, on existing copyright implementation, existing art. Our Andy Thomas clearly does his own art, but he works off of, even when he's doing a living person, he generally will come in, take pictures, and take those pictures back in order to do his work. It's a style, and it works very well for him, obviously. I asked that more for all of us to opine on afterwards. I do have one similar situation. If we believe Wikipedia as always correct, the Beatles derived their inspiration from, among others, Elvis and Chuck Berry. Elvis gave credit to his inspiration, including none other than Dean Martin. Dean Martin credited the Mills Brothers and Perry Como, and Perry Como gave significant credit to his inspiration to Bing Crosby. Oddly enough, Bing and each of those people were all alive at one point, all entitled to their copyrights at the same time. And yet we were able to work our way through who, what, where. Every one of these artists undoubtedly took sheet music and practiced with those inspirations that they had. And every one of them listened to those people's recordings, and undoubtedly every one of them performed and tried to do it, at least in training, in that style. So the question I ask, and I'll just go right down the line, starting with Cy. We have a conundrum here at a minimum. If I am taking a class, high school, college, whatever, the material used for that is typically paid for as copyrighted material once in order to educate me. After that, my education, assuming I'm not using the script itself, my education goes forward without further copyright. If I take a significant amount from one of those college books that I purchased on which the copyright was paid, I have an obligation to disclose it, and if it's beyond a snippet, to pay. Is that really what you believe is at the root of how computers, and I apologize to Mr. Irwin, learn or collect data?
I think the analogy is a very close one, both as a legal matter and as Mr. Professor Callison Birch can talk about the technology, but at least as I understand the technology, that is also true as well, that the copyrighted works are being used not to create a collage or record the copyrightable content within them, but to simply learn statistical facts about the works themselves. And it's a very similar process to the way humans learn.
So kind of like what we're doing right now. I'm actually using this video to bring awareness and so that we could all learn at the same time about the artificial intelligence and what they plan on doing with it. Kind of like that, right? I'm just asking a question.
Now, the problem with machines is that they learn much more inefficiently than humans do. I can read 3 or 4 books about a topic and then be conversant about that topic and maybe even write my own article about that topic. Machines are not that skilled. They haven't quite caught up to us yet. And so they require to do a
Facts, they're not skilled, they're programmed.
similar kind of learning. They require billions and billions of pieces of work in order to reach those same learnings.
But just because they're a bad student doesn't mean that the copyrighted material shouldn't be paid for, does it?
Now, the question of whether it should be paid for is a different question.
He kind of stuttered on that question right there. He don't know how to answer this question right here.
But you're the lawyer, and gentlemen on this end want their work paid for, even if it's used in the classroom. And that's the final part of this question, bringing it all back together, is you two have been very good at calling this education, training, et cetera. And if the analogy of the classroom, of teaching, of learning is there is also the analogy that this copyrighted material is paid for. You know, you didn't go to the public library, so to speak. You went and got this material and ingested it, just as I ingested, for the most part, my college years. So I'll go to Mr. Birch. I really want to get through this for everyone because I think it's part of what brings a close to this hearing.
Thank you. This is a great analogy. So again, I think it highlights the fact that these systems are learning and they're learning facts about the world, and those facts are not copyrightable. I think where the material is acquired from and whether that's fair use or not fair use is exactly the right question. You know, many of my students learn by going out to the internet and retrieving facts from the internet. They do not pay for. That is what's happening here. And so I think—
You mean you haven't published a book that you make them buy, like my professors?
I have
comment.
not published a book that I have forced my students to buy.
Mr. Irwin.
I think what was really interesting in your little Wikipedia piece you read was the word inspiration. And I think inspiration is what we need to keep hold of here, because there's a big difference between getting a book and you know, you want to emulate your idol, you want to emulate the Beatles, or you want to emulate the Rolling Stones. You know, in my case, growing up, my parents bought me sheet music. The sheet music was Mozart or Beethoven. It was public domain, but they still had to buy the sheet music for me to learn. And I learned how Beethoven writes music, and I learned how Mozart writes music, and I learned the Beatles, and I learned all these things, and I learned them. But every time, in your case, the inspiration was, did they hear it on the radio? If they heard it on the radio, there were royalties being paid. If they bought the sheet music, there were royalties being paid. If they bought the record and took it home and played it, there were royalties being paid. And that's really where we are now. Yes, they were learning, but that inspiration was paid for at every time along the way.
That's
Mr.
interesting.
Irwin's hit it on the head with the notion of inspiration. I don't think we should ever litigate against inspiration. That's how we evolve as a culture. And I think the beauty of it is that no matter how inspired you are, you're never going to get it perfect. Therein lies the individuality of the subsequent artist, is they bring their own stamp to whatever they learned on. I learned on many singers to develop myself as a singer.
You're not giving credit to one the way the Wikipedia did for these?
Well, no, there are a few, it branches out. But we still change things a little bit. Also, with regard to stuff like that, you know, I spent some years in advertising before I became a professional songwriter and musician. And I date back from the era where if it got too close on the radio, you said, celebrity voice impersonated. You had to reveal it, that it was an impersonation, lest somebody, Tom Waits and Bette Midler with that. All this is to say is that inspiration should never be stifled. And I'm not interested in stifling technology. We benefit from it. Guardrails, credit, compensation, consent, credit, compensation. Thank you.
Mr. Sedley.
I agree with my colleagues. And your example of the classroom is very insightful. You know, one of the largest areas for copyright licensing is educational use, the textbook industry, and in turn, photography and illustrations being licensed for educational use. If you want to teach in the classroom about B.B. King, you can't use my photograph of B.B. King without licensing that photograph. If you want to teach about me or my photograph of B.B. King, that's going to be fair use. It's true that all artists have been influenced.
Facts, and it's supposed to be the same way for us. When somebody uses our pictures or uses something that we use, something that we make, something that, like for example, we make a video and somebody comes into our Facebook, right, or anywhere, it should be fair use, but it's not fair use if it's public, if it's out here on Facebook. It becomes theirs allegedly. So that's crazy, right? Because we should be protected by that copyright too, as citizens, as we the people. But why aren't we?
Influenced by others, and there's a difference between influence and inspiration or copying or theft.
That's what makes it easy for me to do this commentary and this reaction, because this is public information. Once it's out here on the web, it's public, unless it's a private site.
All of our works are made based on our lived experience as humans, and taking those works and being inspired by multiple of them to create, for example, the portrait that you showed. If you relied on multiple portraits to create each individual portrait and was inspired by them rather than copying them, then there might not be an infringement there. If he traced it on a light box, if he projected it on the canvas, if he copied all of the expression or the heart of the expression, there might be infringement there. That's a case-by-case, fact-dependent analysis.
And one of the interesting things about Andy Thomas is he manages to capture each of these men, both Republicans and Democrats, better than they were, which is something that a computer probably will take a long time to learn to do. Well, in closing, there are two things that were not discussed fully. One is the fact that even if copyright use is not attributable to a single artist, in other words, the trillion into the works may not be effectively able to be done, it doesn't mean that the ingestion of that material should not somehow go to the benefit of the copyright industry as a whole. And that'll be one of the things that is not a statutory remedy today, but could be. You know, to a certain extent, it's like orphan works. You can't necessarily get them back to somebody, but you don't get to use them completely for free just because we can't assign them. The last one, which was brought up here today, and I'd like all of you to opine on it, because I think it was a real threat, but there wasn't time in this hearing to pick it up. In patents, in copyrights, and in trademarks currently based on some bad actors, computers can generate an infinite amount of combinations. If they generate an infinite amount of combinations of copyright material, they could in fact create a body of copyright that could eclipse future innovation, simply push out tens or hundreds of trillions of songs, of variations of art, and in fact then make a claim, a troll-like claim, that everybody else who comes up with an original piece, there I find enough to say that you took it from me, even though you may never have seen the trillion different outputs. It doesn't sound, it sounds far-fetched until those of you who look at AI and look at the petabytes per minute now that are being ingested on the internet, and you realize that in fact infinity is closer to us than we ever thought it was. So I'd like you to opine on that, because one of the challenges that I face is to limit copyright or patent applications or trademark applications that are computer generated if in fact they serve only to limit humans' ability to do individual creation. And I'd like you to all opine on that within your own expertise. We'll leave the record open for the next, I think 5 days is the committee rule, but I'll shove it in if I get it later, as long as the chairman lets me. So I want to thank you. I expect that we have your numbers. We will be calling you. You have our contact information. I would hope that you continue to help us. Mr. Ranking Member, do you have any closing statements?
I do not, other than to thank the witnesses for your testimony today.
And with that, we stand adjourned.
All right, y'all. So for the whole day today and for part two, well, let's put it like this. For the past couple lives, part 2, part 3, and now part 4, you know, we've been watching this meeting, this committee meeting. They've been talking about, you know, they've been talking about the copyrights and much more. In my opinion, I feel like this was more of a trial. I feel as though they're just trying like to pass a bill or a law or something like that. It like similar to that. Maybe I'm wrong, but I've been, you know, been watching a lot of videos, been watching a lot of these meetings and stuff like that. And they ready. They want to bring in these robot judges. Like they already got the canine dogs, they got the RoboCops some in certain places, like wake up, smell of coffee is here. For those of y'all that are like, oh damn man, we gotta do something to stop the Jetsons area. It's here. It's here. Like we had time to wake up. We called all them old heads that passed away that are not here no more. Crazy shout out and much more. And guess what? We've watched these movies from iRobot, the movies with Will Smith, Terminator, Matrix, and much more. Now we're about to hop into this. I gave y'all my